Okay, welcome everyone to session 25, Adapting the Law to Major Technological Shifts, Lessons from History Applied to Current AI Challenges. This is a joint session hosted by the Center for Intellectual Property by Innovation and Policy at Dillon School of the Law School, George Mason University, as part of our WIPO US Summer School with the US IP Alliance, the Lemelson Center for the Study of Invention and Innovation at Smithsonian, and the Consortium for Science, Policy, and Outcomes at Arizona State University. We'll be joined by Rama Elluru at the Special Competitive Studies Project, Arthur Daemmrich at the Arizona State University Consortium for Science, Policy, and Outcomes, Dave Kappos, Cravath, Swaine, and more, former director of the United States Patent and Trademark Office, Amy Sedem at the University of Buffalo School of Law, and Tarub Vishnu-Bakat at Benjamin Cardozo School of Law. And I'm Joshua Kresh, the Interim Executive Director of the Center for Intellectual Property by Innovation Policy. I think Arthur's going to kick us off with some history to start, and then we'll go through each of the panelists who will introduce themselves in a bit more detail and provide some opening comments, and then we'll turn to a Q&A session.
Yeah, hi everyone. Delighted to be here, and thank you, Joshua, for bringing us all together. So, we're talking today about the pace of technology change and how to think about the law in relation to technology change. And of course, we're going to spend a fair amount of the time talking about AI. I wanted to, as a historian, take a step back and go further back in time and think about intellectual property in relation to copyright and authorship. And so let me just start and say, the notion of an author is really quite ancient, but really for a huge amount of human history, it had a less individualistic concept than we really think about and use today. And the property rights that we consider really important to sparking new ideas and rewarding effort have been seen in rather different ways through history. So if I take a step back, the oldest oral traditions from pre-recorded through ancient Greece, the individual authorship is kind of interwoven with the fact that there's hundreds of years of subsequent embellishing, variation, and updates. And if I could get the next slide. When we come to the Roman Empire, authors now could really sell their plays and other literary works to wealthy sponsors and donors, and a respectable house had a library. They could purchase the manuscripts in these sort of rolled forms, and wealthier people on their staff would have a transcriber who would duplicate scrolls. So the literary authorship didn't necessarily get special legal protection, but there was some accreditation to the individual to some degree, but it's kind of messy in all honesty. And then, of course, we get the technology change, if I get the next slide, of the printing press. And here it is that recognizing the author and rewarding the author, but more importantly at the time, the book publisher, raises some complex issues for the law to resolve. And so the Gutenberg approach really raised this question of who owns the literary, artistic, or historical work being printed. And for several hundred years, the answer is the publisher. And you'll note that, the piece I chose here from Ecclesiastes is this infamous quote that people who study innovation, of course, want to tackle, which is this issue that there is no new thing under the sun, which of course we push against through intellectual property rights, right? We try to create new things. If I could get the next slide. The Gutenberg process and the rise and spread of printing raised a dilemma of low-cost duplicators. So competing publishers were soon copying each other's works, discounting prices, and increasing sales. This satirical print, Werke der Finsternis, shows a publisher well-dressed in the center as a highway robber. He has two assistants behind him, sort of under the cave, who have stripped this other publisher of his coat. And to the left, you see people fleeing these highway robbers. Justice has fallen asleep. And so, this is a concern, and what it's pointing to is that publishers are undermining each other by copying and duplicating the works. In common law countries, the 1710 Statute of Anne in Britain allowed for books and then other works to be copyrighted. And over the course of the 18th century, we see the development of the author's name, image, and style becomes recognizable and monetized. So today's name, image, likeness business that we hear in sports has its roots in the Enlightenment. And if you look at famous 18th century works, Adam Smith, Wealth of Nations, for example, and numerous others, you'll see an image, a frontispiece of that author, and that becomes integral to the identity of the author and then compensation. Jumping forward, 1790, of course, the US Constitution includes its famous provision to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And within months, really, the first copyright laws enacted in the United States, protecting books, maps, and charts for 14 years. Those works are registered in the US district courts. Now, changes to communications, entertainment, educational technology led to changes in regulation, often with a time lag that frustrated the inventors and creators. But in retrospect, it also gave time for that technology to stabilize. If I could get the next slide. And in the early 1900s, we see a key example of this. The player piano takes off. It's not just in Western saloons, as most of us think. They come down in price and become commonplace, even in wealthier people's homes. By 1903, one of the bigger companies has over 9,000 titles in its catalog, these rolls of paper with the program for the music. In 1908, a key Supreme Court decision that later comes to bear on computer software, the question had arisen whether piano rolls could be protected. Are they property of the composer of the music? The player piano companies were refusing to pay royalties, arguing that the rolls aren't read by humans and are different from sheet music. The court sides with the industry initially and finds that they are not copies of musical work, but instructions for the piano. Quickly, Congress reacts in 1909, changing the copyright law to allow copyrights on piano rolls and other musical recordings. It also establishes a compulsory license, so anyone who wants to make a recording of a musical work can do so. So here they've kind of opened it up to more of a free market. These sets of issues come back in the course of software as it shifts from something encoded in the mainframe to a program you have to load onto a personal computer. And is that software a literary work or a set of instructions? And that gets clarified somewhat in 1976 with the Copyright Act that states that works expressed in words, numbers, or other verbal or numerical symbols, regardless of the nature of the material objects in which they are embodied, can be copyrighted. And next slide, this is my last slide, jumping up to the present. So of course we saw some people on this will remember it well, others, this is sort of ancient history from their childhood perhaps, but we saw the invention of Napster as a peer-to-peer file sharing network. In other words, you could basically reach through and copy music off someone else's computer. Courts quickly established there's a difference between me purchasing a copyrighted piece of music and then having it on multiple devices that I own versus somebody else getting a copy of this or me sharing it among various people. And that leads to the demise of Napster then. And then in kind of my final case for this discussion, we have the famous monkey selfie. So this photographer had left his equipment out and a crested macaque took several selfie photos. When the photographer, David Slater, sought to register the photos, they had already been widely published and were enormously popular. The Copyright Office ruled that non-humans cannot legally own a copyright. PETA, the Organization for the Ethical Treatment of Animals, also filed a lawsuit seeking to get copyright, which was then dismissed in 2018. The key insight, I think, out of this history is that a property right is something different from creativity or expression. So gorilla or monkey can take a photograph, elephants and other animals can paint, crows can make tools, orcas can learn to sink ships. That doesn't give them the basis for owning intellectual property. And that's the deep issue we're really struggling with, or one of the ones that has to do with artificial intelligence. So, the property rights have been an incentive to create further. Granting the products of AI copyright or other property rights would really raise quite a challenging set of issues about whether that's incentivizing the further creation of public goods that we seek, or, are we opening up additional creativity or shutting it down? So let me stop there, turn it over to our other wonderful panelists, and look forward to the discussion.
Thank you very much, Arthur. Sarah, do you have a little bit of history on some patent areas of change over time that you want to kick us off with?
Absolutely. So I certainly echo Arthur's thanks for your bringing us together, Joshua. So what I would like to do is make a related set of points to Arthur's terrific presentation. His thesis, as I understand it just now, is that over the arc of history, we've treated the subject matter of the intellectual property grant differently, right? The nature of the property right as connected to the subject matter involved. And that's the problem that AI poses for patent law as well. There's a related set of questions about how the law and how legal institutions should respond. One way might be to say it should respond prospectively rather than reactively once the technology has stabilized. That's a debate that's going on right now. Another sort of possibility in that debate is that the law might proceed industry by industry rather than trying to come up with a transsubstantive set of legal rules, even within the domain of patent law. That's something that the patent law and copyright law have done differently over the years. Copyright is very specific as to the medium of expression, whereas patent law tends to favor, in the words of a National Academy of Sciences report from the early 2000s, a unified, flexible set of standards that can be applied across the board, rather than industry-specific rules that might be subject to problems like political capture. So the history that I want to share is sort of in service of that question of how should we act, by asking, well, how have we acted in the course of U.S. patent history? And I'll give you sort of 4 historical examples and one very recent example, all of which point us toward the nature of artificial intelligence and AI-related technologies as what economists call general purpose technology. So this is, as a quick preface, from work that I have done with my former boss and co-author, Stuart Graham, who was the first chief economist of the USPTO when we worked at the agency during Director Kappos' administration. And this paper was published about a decade ago in the Journal of Economic Perspectives. So I encourage you to look at that paper if you're interested in the deeper story. We begin at the turn of the 18th century, 1794. Eli Whitney patents the mechanical cotton gin. Its full sort of technological and social impact wouldn't be felt, or we wouldn't finish sort of feeling that impact until many decades later, but there were pretty immediate productivity gains as a result of the cotton gin. But Mr. Whitney was unable to recoup most of what we would consider the rightful returns from that innovation. And there was sort of wholesale infringement that took place for many years into the early 1800s because local juries who resented Whitney for taking large royalties from farmers refused to rule against him. And it really took amendment to the federal patent law in 1800 that Whitney's legal rights were finally vindicated. And even then, there was only limited reward because the technology had become so widespread by then. So a legal change took place in response to a perceived injustice, but it was reactive. And it really took an act of Congress to right what was ultimately perceived to be a wrong. Now we fast forward about a half century to the mid-1840s. Elias Howe in 1846 has patented the eye-pointed needle sewing machine. Again, huge productivity gains, new economic freedoms, particularly for women, who at this time were the ones mostly involved in textile-related technology consumption. And it leads to extensive litigation among industry rivals, particularly with folks like Isaac Singer, who had tried successfully to invalidate Elias Howe's patent. But again, the legal landscape changed, this time not through the change of statutes or the patent office, which by this point was a little over a decade old. Instead, what we see is a private market innovation in legal instruments, and that's the introduction of patent pools. which is a set of collective contracts by which Howe's patents and Singer's patents and those of others were joined together into a pool, and there was wide cross-licensing to allow entry into the market. Now, the mutual blocking patent problem had been recognized prior to this, and Howe himself was not a manufacturer of sewing machine. He was a patent holder interested in licensing his innovation. So by modern standards, we might call him a non-practicing entity, or we might even use some uglier language like the T word, troll. But the sort of lesson of the Howe and Singer dispute is that it doesn't take a legal change necessarily. It can come about through private ordering and market solutions, through contracts and pools. Now, yet another half century after that, I'm going pretty much in 50-year increments here. Orwell and Wilbur Wright, they patent the wing and steering designs of the flying machine in 1906. They show their work to the Aerial Experiment Association, which had been founded the following year by another well-known inventor and well-known patent litigant, Alexander Graham Bell. But the Wright brothers had refused a license from Glenn Curtiss for his engine, and so there was widespread litigation when Curtiss and other industry players infringed on the Wright brothers' steering patents. Now, a private industry or sort of intra-industry dispute, even a large one, is not necessarily the end of the world, except very soon after this, the United States is mired in the First World War, and the Assistant Secretary of the Navy, Franklin Roosevelt, in 1917, pressures the rivals to learn from the lesson of the sewing machine patent pools. And so we see the introduction of the airplane patent pool and the resolution of that litigation. But two things are quite different. One is a much firmer hand by the government in the person of the Department of the Navy, the Department of War. And the other is that the cross-license actually results in Curtiss-Wright Aircraft, a sort of formalized partnership, what we would consider in modern terms, the economic firm, rather than lots of distinct industry players sort of decentralized in their usage of the patent pool. So again, the response is a private one, but it's probably better to characterize it as a sort of public-private hybrid. And so one more example of a different way in which the dispute could be handled. And then the fourth and final major case study, half century after this, in the 1950s, 1957, a graduate student at Columbia University named Gordon Gould sketches some calculations in his lab notebook of the first laser. And Gould soon leaves the university for a private research firm. Other scientists independently develop the same technology, but of course, independent invention is not a defense to infringement in patent law. And as a result, by the 1970s and 80s, what we see is a decades-long dispute where patents that had previously been prosecuted while in secret, as the law provided, suddenly were granted, emerged from underwater, as we would call them submarine patents in modern parlance. And as a result, it caught industry by surprise because the technology had progressed by that point so far that these patents were really able to constrain the behavior of an entire industry, not just of a few firms. And ultimately, Gould prevails, right? His invention has priority over just about everybody else. And so the problem of submarine patents in that case couldn't be solved retrospectively. However, going forward, what we see is in 1995, the accession of the United States to the General Agreement on Tariffs and Trade and the subsequent enactment in the United States domestic law of the American Inventors Protection Act provides for what is now familiar publication of patent applications in most cases at 18 months from filing to avoid the problem of submarining. So again, we see a formal legal response, not merely a private or public-private hybrid response. And going forward, the problem of submarining is much diminished. Now, the current and most recent example, and this is the one I'll close with, is the smartphone patent wars, right? What does it mean for a software patent to encumber an entire industry? such as it was purported to about a decade ago. Now, my paper with Dr. Graham in the Journal of Economic Perspectives was really intended as a cautionary tale against the moral panic, what we saw as a moral panic about software patents. But the idea is basically that many of these technologies, and AI is certainly something that follows in this mold, have the purpose of general purpose have the characteristics of general purpose technologies, in that they are widely adopted across many tech sectors and economic sectors. Generality is something we can measure, and economists do measure it. And so when we think about AI and related applications of AI, one thing that we ought to do is learn from history, because there's certainly a lot of history to learn from. And the other is that we ought to rely on economic evidence, empirical, rigorous evidence on which we can engage in evidence-based policymaking, which has led to, I think, some of the more sustained and successful innovations in patent policy over the last many decades. So those are my prepared remarks. I look forward to our discussion. Thank you.
Thank you very much. Turning to Amy.
Yes, so following up, I would like to just talk for a few minutes about how the rise in AI technologies raises a host of issues for our existing legal system, both with respect to regulation and with respect to the patent system in general. So first, with respect to regulation, AI regulation has largely been driven by a collaborative model of regulation between the government entities and private actors. But the private actors have a lot more of the information with respect to the technology at issue. And as we're going forward and we see countries around the world trying to confront AI regulation, we see that's largely divided into two main issues, really, namely regulating AI development, namely how do we incentivize AI inventions, and then regulating the AI after effects. We saw this with respect to social media, for example. In the 2000s and 1990s, the internet was largely, unregulated, and it was only later that we saw that the impact that social media can have negative implications, and the government's taking proactive action, or at least having hearings with respect to mitigating some of those effects. So we see some now countries now taking the lead with respect to trying to regulate AI after effects, namely issues that may arise with respect to algorithmic bias, ethical decision-making, data privacy, and the like. We also saw this with respect to data privacy regulation, where there was a void with respect to who was regulating it. And then we later saw that in the United States, for example, many states having their own data privacy regulations. So although AI has been in use for over 7 decades, depending on how you define it, it's only really now that we see governments around the world trying to devise ways to regulate it. And governments may have different aims with respect to how they might regulate AI. Namely, are they trying to regulate AI to incentivize AI development, or are they going to focus on regulating the AI after effects? Countries like the US and China lead in AI patenting, and something like 4 countries, Japan, United States, China, and Korea, at least as of 2019, this probably might have changed since then, had 86% of AI inventions. So they might have a different aim with respect to regulating AI invention than countries that maybe don't have as much AI innovation. Countries may also differ in how they regulate versus, do they regulate versus a statute, an agency, how you define an AI invention, how you define the risk, and whatnot. And so, yeah, so going forward, countries around the world are going to have to deal with how to regulate AI. Another illegal issue that that governments have to deal with is how should we patent AI inventions, and how do we adopt the existing patent law framework to AI inventions? I have done some research with respect to looking at U.S. litigation in district courts and comparing how AI inventions differ from non-AI inventions. And it's disproportionately true that under Section 101, the Alice Mayer framework is the basis in which patents can be declared ineligible based on subject matter. And AI inventions, at least currently, are disproportionately invalidated under Section 101. compared to non-AI inventions. So as AI inventions become more prevalent, and as they become more prevalent, we're going to see more litigation with respect to AI inventions. We're going to see the tension rising more with respect to how Section 101 should perhaps maybe be reformed or adjusted to deal with AI inventions. And this also brings the United States into conflict with the rest of the world with respect to defining eligible subject matter, because some countries are less restrictive with respect to patent eligibility when a software-based invention is tied to hardware. So as we have more AI inventions, we might see more tension with respect to U.S. inventions being validated at a different rate than inventions in other countries, which have a different laws with respect to patent eligibility. So going forward, we just have governments around the world have a lot of issues to deal with respect to defining how AI should be regulated, what the government's aims are with respect to AI, and how to adjust the patent system to deal with AI inventions.
Thank you very much, Amy. And having brought up a little bit about some of the regulatory challenges and how different countries around the world are looking at it, let's turn to Dave to talk a little about the U.S. style of regulation and legislation and how it compares to the EU in particular.
Yeah, thanks, Joshua. Great to be with everyone this afternoon, and great to be working with some really fantastic colleagues and scholars on these AI-related topics. As Joshua said, I'll sort of pick up and drill a bit more into some of the points that Amy made regarding different regulatory approaches taken by different countries. So, what we've seen so far in AI, since its explosion into the public consciousness now, whatever, 2.5 years ago or so, is a juxtaposition of regulatory approaches in different parts of the world. It repeatedly through history, and you heard some of this from Saurabh, and you heard some of it from Arthur also, when a new technology comes onto the scene, governments have to decide how to deal with it, whether to regulate it, how to regulate it, whether to work with the private sector in determining how to regulate it. To some extent, allocation of advantage and opportunity and consumer surplus or general surplus from this new technology. And AI is no different from other historical or from historical examples. It's a current example. We saw this, with technologies like the internet most recently. We've seen it with computers and software in general, as has been mentioned, and then going back in history with more mechanical technologies. In recent years or decades, there's become quite a distinct approach that's been taken to regulation of new technologies, as between Europe in particular and the US, and more recently, since China has emerged as, I'll call it the third major power, generally the Chinese approach. In the US so far, with respect to AI, there's no federal legislation that's been created. There have been plenty of hearings and discussion, and that's in keeping with the US approach of letting technology develop and then regulating it reactively and not proactively. And some would say maybe that's one of the reasons why the world's leading AI development is mostly occurring in the US. I won't try and take a position on that, but it is a position others have taken. What you do see in the US is now literally hundreds and hundreds, and I mean that, hundreds and hundreds of state level laws being considered, and some that have already been passed by some of the more dominant states like California as an example. And those laws are tending to focus on issues like some of the ones that Amy already mentioned, consumer protection, protection against AI-related bias, AI-related discrimination, what's called consequential decision-making, decisions about whether you get insurance, whether you get a loan, whether you get credit, those kinds of things. And so there's a lot of state legislation focused on that. There's a lot of state legislation also focused on transparency, just making clear that AI is being used to do something, to produce that text, that picture, or whatever. Juxtapose that against the approach that's being taken in Europe, where, as they say nowadays, and this again is my quip, it's one that others have used, the US innovates, China copies, Europe regulates. And the Europeans, true to form, have come up with broad, region-wide regulation, trying perhaps to capitalize on what's called the Brussels effect, that took hold with the GDPR and privacy regulation, 5, 6, 7 years ago, whereby setting the regulatory benchmark, Europe was able to significantly get the world to follow and set similar benchmarks. Unclear whether that'll work for AI, but in any event, Europe now has enforced what's called the AI Act, broad, continent-wide or member-wide legislation that is passed and in force that divides AI applications into a number of categories, from extremely risky things like use of AI in controlling weapons, AI for profiling people, those kinds of things that that the Europeans would say you'd only want the defense forces under certain circumstances or police forces to be using that kind of technology, all the way over on the other extreme to low risk uses of AI, in some activities that we all want to participate in, like writing a limerick or something like that. And then categories in between. And as has been the case with Europe in the past, exacting very heavy fines, especially on companies that fail to meet the regulatory requirements. So you've got very different approaches. European approach, regulate in advance, with a heavy focus on protection of consumers, of citizens, of residents. US approach, regulate reactively after the fact, with a heavy focus on incenting and allowing innovation to take hold. And then lastly, I'll mention, and then I'll stop, the Chinese approach, which is, the Chinese, to their credit, have their own, very robust AI laws, and some of which went in place, very early on, taking the approach of, look, the government owns the data. The government has rights in AI technology and the data that's being produced in China, about Chinese people, about whatever goes on in China. And so the government gets to control. And you can imagine there are some advantages and some disadvantages to that approach also. It's culturally rooted, of course. But you could see some social experiments going on with very different approaches being taken. Stop there and turn it back over to you, Joshua.
Thank you very much, Dave. Rama, I think you want to add some more specifics on the EU.
Yeah, thank you, Joshua. Thanks, everyone. It's great to be part of this conversation. As former Director Kappos eloquently explained, the European Union Artificial Intelligence Act, EU AI Act for short, is very reactive. It's very proactive. They were dead set on being wanting to be sort of the first democratic nation to set out a comprehensive framework for AI, and they did so. It goes into force this month, full effect probably in 2026. It's comprehensive legislation. It provides developers and deployers with the requirements and obligations. It actually has different requirements for the different players in the AI value chain. For example, the provider to the developer, the deployer and distributor, and so on. And each one of those might have different compliance requirements. Similar to the GDPR, the EUI Act applies to companies across all sectors that develop or distribute AI in the EU market. It has extrajudicial applications as well. So even if an American company wanted to provide products and services in the EU, they would have to comply with the EU AI Act. And as former Director Kappos explained, it's a risk-based approach. There's 3 broad categories of banned uses, high-risk AI systems, and low-risk systems, adding to examples of unacceptable risks. These include things like social scoring, subliminal techniques like any sort of AI that manipulates behavior. Most of the text of the EUI Act focuses on high-risk systems, including those used in critical infrastructure, education, healthcare, financial services. And so the limited risk systems, the ones that don't have much risk or harmful implications, have the least requirements, least obligations to follow. And there's also they also cover general purpose AI models, and they take a 2-tiered approach. AI general purpose AI with exceptions for models used only in research or published under open source licenses. These will be subject to transparency requirements, as well as compliance with copyright laws. Models with high impact capabilities or have systemic risks have higher cyber requirements like cybersecurity checks, requirements to release details of the architecture and the data sources used. And then all providers of general purpose AI models have to also do things like provide technical documentation, supply information, instructions to downstream providers, etc. I think, as former Director Kappos mentioned, the objectives of the EUI Act and I think the US approach are similar, although again, I think the EU is much more proactive and we are reactive. And we also have to look at this in the context of what's happening right now. There is a global tech competition. Nations are trying to influence global order by their tech leadership. So I think the United States is trying to balance innovation with regulation in this context. So leaning more towards innovation because the United States, as other nations compete, want to be the tech leaders because this means military might, it means economic prosperity, it means social prosperity. It also means that our values, if we are the tech leaders, it means that we are going to be instilling the values in these technologies that are exported around the world, and we want them to have democratic values in them. So in this sense, I think the EU and the United States have shared objectives. Again, I think implementation is a little different. I think the risk-based approach that the EUA Act takes is a little bit rigid and static. They have lists of AI uses and technologies that are considered high risk, and those are soon going to be outdated because this technology is moving so fast. So I think the United States should and is looking towards regulatory frameworks that are a little more flexible and agile that can keep up with the technology. And so I'll stop there, but I think there are some shared ideals between the EU and the United States. And as far as, I'll just add one last comment about China, their AI regulations is actually very comprehensive. But their exceptions to those regulations are very large. So, for example, with respect to data privacy, they do want to protect individual data from each other. However, the state interests take precedence. So there's really huge exceptions for how the state can use personal data. And I'll stop there. Thank you.
Thank you very much. And I see there's a couple of questions in the chat. We're going to do a couple more general questions to set the stage, and then we'll turn to the chat in a little bit. The first question is a multi-part question, and it's not easy, so I'll leave it open to anyone to answer as much as you want or as little. We've talked a bit about some of the different regulations and things they cover, and there's been a lot of discussion about specific challenges that AI can present to the existing legal system. So how do we decide, what are the types of challenges that are new for AI that require new laws, new regulations? What are the ones that really fit under the current system we already have and maybe just require some tweaks? And given that we talked about the international point to all of this, what are ones that can actually be handled on a country by country basis, and what are ones that you sort of have to decide as a world, because if one country says you can't do this here, well, another country may allow you to do it, and it's still going to happen anyway. And I'll open this to whoever wants to start.
So if I may offer one object lesson from how the U.S., and particularly the USPTO, dealt with this very set of questions during the software patent debate as it pertained to smartphones, but really in the late 2000s and the first half of the 2010s, I think, and roughly an 8-year period, the USPTO was a relatively late adopter of the innovation of having a chief economist, right? WIPO, DPO, the UK IPO, these folks had chief economist functions in their offices for some time. Now, once the USPTO got involved, obviously the significant leadership that we show as an institution with other national IP offices around the world, and the significant information, data sharing, and work sharing that the agencies engage in, mean that the chief economist had very little, the U.S. chief economist had very little time or trouble getting sort of plugged into that debate. And one of the great outputs of that collaboration was a common baseline for how empirical data about these trends and phenomena should be collected. I think that's a really valuable initial step we can take to serve as a platform for future research in evidence-based policymaking. When we have a common set of definitions, what counts as AI, what doesn't, what are the categories, what are the mechanisms and methods by which we collect data and track trends over time or across economic sectors, we sort of give each other a common vocabulary with which to set policy. And that's the conversation that lets us have all the other conversations. So I've certainly seen the Office of the Chief Economist at the USPTO grow in capacity over the years, and I think that would be a terrific use of its talents.
Yeah, and Joshua, just adding to that, I couldn't agree more with what Saurabh just explained about the pivotal role and that the Chief Economist's office played once it was populated by Stuart Graham and Saurabh, and does play now. And if you step back and ask yourself the question, so how and why, it's because economists are thinking about economic results, no surprise, and about how the intellectual property system achieves something that people other than intellectual property lawyers care about, which is, as Rama was saying, economic outcomes, innovation leadership, prosperity, jobs, right? Things everybody cares about. That's what economists focus on. And that kind of skill in the AI revolution, in the AI era, and that kind of focus as a starting point is so critical. So that's point number one. I'll make one other point, which is to say, coming back to your question, Joshua, which is, how should we think about where to regulate, when to regulate, how heavy a hand to put on the regulation? Number one, again, we should listen to the economists. Number two, we should optimize innovation. We should lean in toward optimizing innovation. And where there's any question about the intellectual property laws applying or not applying, we should make them apply, because the intellectual property laws are our vehicle for incenting innovation. We don't have another vehicle. They are the game, end to end. So this is why I would say, as we go forward and finer decisions get made and regulations are put in place that touch on issues like, what disclosures are required to patent granting authorities when AI is involved in creating an invention. We should go as light as we can. We should learn from history, right? AI is a tool. It's a very powerful tool. It's a great tool. But you know what? The microscope was a great tool too, and a very powerful tool when it was created. Did we create rules in our patent granting authorities around the world requiring the disclosure of the use of microscopes when they're used in the process of making an invention? Of course not. We didn't require disclosure of the use of nail guns either, and those are powerful tools, or any of the other powerful tools that we have available to us. And we ought to be really careful about doing that now. Instead, we ought to take a view that as much as reasonably possible, we love inventions and innovation of all kind, copyright-related innovation, trade secret-related innovation, patent-related innovation that touches on artificial intelligence. We want that to grow as fast as possible for all the reasons that Saurabh will tell you are huge opportunities because of the economic advantages they create.
I'll add also, I mean, AI, as I think everyone would agree, is a transforming technology. We want the benefits, and the way to get the benefits of this is through mitigating the harms and careful, thoughtful regulation. So we should have regulation, but it should be towards the end of harnessing the benefits for our economy and society. And I think one of the levers for fueling innovation, as has been pointed out, is intellectual property. I mean, and then you don't have to go very far to see that, for example, the PRC has recognized intellectual property as a powerful lever for for strengthening its innovation base, because it is strengthening its IP system, it's strengthening its IP laws, its IP infrastructure, it's putting into place IP mechanisms to incentivize further innovation.
So if I can jump in, I mean, I've done some work on the history of food and drug regulation, and it's, let me warn, that's not necessarily the right analogy for this in any way, shape, or form, but we've built regulation there on the backs of fundamentally disasters, right? So sulfanilamide tainted in 1938 food and drug reaction to a tragedy of over 106 children dying. 1962 Food and Drug Act that introduces a 3-phase clinical trial then and really revamps how we think about pre-market controls. That comes in the wake of the thalidomide disaster. It's not at all clear AI is headed in that direction of direct kinds of harms that lead to that kind of congressional response and regulation. But, to your question, what would be the circumstances that lead to such a regulation? That would be a way it comes about. And in many instances, then those laws are written somewhat hastily, right, and lead to quite a complex set of second-order impacts. That said, regulation can shape industries in ways that forces them to generate more public goods, or at least public information. So you can require some greater transparency out of them, whether it's testing their product in some controlled clinical trial type setting or some other form of disclosure. And AI as a field and as an industry might actually benefit from some greater information and disclosure, right? The idea that these are black boxed and that some of the inventors themselves say, oh, I don't actually know what's going on inside. That's not ideal for some of the use cases that are being developed.
Yeah, so talking about some of the specific regulations and going to the IP system in particular, the Patent Office has put out a couple of requests for comments. Some responses are already in, they've reopened, and some that are pending this summer, that ask a couple of key questions, some of which we've talked about and some which we haven't quite got to yet, but I think I see some questions in the chat on. So the questions for the Patent Office now, and one is not really one of their requests for comments, but it is a question I think a few people here will have some comments on, is should new AI algorithms and inventions be patent eligible? And how does that work under current 101? And then if we want to a little bit talk about some pending legislation and how that could change things, I think that's the first question. Then we get to a couple other additional questions for the Patent Office, and then also some similar questions the Copyright Office is looking at as well. And whoever wants to answer that to start is it's open.
All right, I'll take the softball one. I think that current patent eligibility laws is still very murky. So it's not going to help with the patent eligibility of AI inventions. AI inventions are typically software, and we've seen what our current patent eligibility regime has done with software inventions. And so I can't see how that would be any different for AI inventions. And, I think we need, if we want to encourage, patent disclosures of inventions under patent disclosures as opposed to trade secrets, I think we're going to have to provide more clarity for the eligibility of AI inventions and software.
Yeah, Rama, I couldn't agree with that more. I just add that setting aside the, very few cases so far in which patent applications have been filed claiming that the invention was made by AI, the not just the vast majority, but all uses of AI that I'm hearing about, and in some cases dealing with, in my day job with clients, involve AI, again, as a tool, as I was mentioning before. Powerful tool, but a tool. AI is not making inventions, it's helping humans make inventions. And I think we need to view it through that lens. For how long, I don't know, but what I'm being told is certainly now and for some period of time in the future, we'll see as time goes on, whether that's more like 1 year, more like 5 years, or more like 50 years. But we ought to keep ourselves grounded at this point and avoid the reflex to panic and discriminate against inventions that touch on AI. And this is why I'm frankly concerned about the direction of PTO regulation and requirements that are putting a dark cloud over any patent or patent application that benefits from whose invention benefits from the use of AI by discriminating, by requiring extra disclosures and statements, because everyone who deals in this world knows that each such requirement will mean that if a patent issues and it proves to be important, an extra $1 million of litigation will occur on extensive discovery, expert opinions, trial testimony, appellate arguments. Everything will get contested, and every patent application that it later can be challenged as having benefited in some way, directly or indirectly, from AI will absolutely be challenged on that basis. So again, we ought to take lessons from history. Did we impose these kinds of requirements on previous technology improvements? Inventions aided by software, inventions aided by microscopes, inventions aided by lasers. I think Saurabh and Arthur talked about that before. We didn't. So, and those were important and powerful tools, and they enabled lots of other inventions to occur. They were platforms, right? Like in a way, AI is a platform, and we ought to be careful about setting up rules that are going to cause inventors to say, you know what, I'm just going to stay away from the patent system. And I'll end, Joshua, by telling you, people like me, and I assume there are thousands of other attorneys in the US alone who are way smarter than I am, who are advising clients on these kinds of issues now. That's exactly what we're telling them. Stay away from the patent system if you can.
I'll add that, and I don't think that's a great way to go. I certainly think that trade secrets are very important IP protection, but there has to be a balance between the different kinds of protections that we have. And the disclosures in patents help innovation. People can build on those innovations. People can build around those inventions. So it's really important to have that open disclosure, which is what the patent system gives. So I think it is something that we need to encourage. Again, if everyone in the innovation space turns to trade secrets, then a lot of that public knowledge sharing is going away, and that's not going to help grow innovation.
Yeah, and if I can just add, I mean, Rama, it takes me back to one of the key points you raised, which is, we often think of technology as sort of value-free, neutral, but, we do embed values in technology. And as you said, if we want to embed democratic values in the technologies, whether or not we're exporting them or we're designing and then ultimately importing them to consume them, we need to do so with some understanding of both the intellectual property disclosure to make that clear and other forms of kind of disclosure of how the technology works and how it can then advance what we want to see both economically and democratically.
Another
Yes.
object, sorry, please.
Oh, yes, and I agree with David with respect to not treating AI inventions differently from other inventions. I see the 101 issue, for example, I mentioned before about patents are AI inventions disproportionately invalidated under 101 compared to non-AI inventions, and that's basically because 101 is the problem. So I think resolving 101 issues with respect to all inventions is really the way to go here, rather than carving out special regulations or laws with respect to AI alone.
An observation that I'll add is I do a lot of work on AI governance as well as intellectual property policy. And there's a lot of emphasis, especially here in the United States, about agency and making sure that there's human oversight. And I think that's also relevant to our patent regime or IP regime, right? So if we want human oversight, human agency to be prevalent, then we should look at AI as a tool, a very sophisticated tool, sure, but we need to configure or re-envision our IP regime so that we are placing the importance on humans.
So one other thing occurs to me in this discussion, which I find fascinating, is we're at a point in AI's development where I'm not sure its epistemological status is totally clear. And what I mean by that is we've often seen in the history of technology, something comes along and it doesn't, fall neatly in one of the boundaries we have. And just to give a somewhat humorous example out of some recent research I did, when the e-mountain bike, these electronic bicycles came on the scene, there's actually quite a bit of a dilemma for Department of Interior. Is this thing a bicycle, human powered, or is it a motorcycle, machine powered? Well, an e-bike is both of those, or neither. And so, they had to go through a whole rulemaking process, public comment, and tried to sort this out. And that's like a pretty simple technology compared to AI. So, I mean, this is, I would argue, an advantage of a common law system that we will now have however many years of court cases, some of which will conflict with each other and drive lots of commentators slightly bananas. But that's kind of the way we will work through it. And it's annoying and, makes people impatient, but I feel like that's sort of our process. I'd be curious what other people on this panel, how this will play out in their minds.
Yeah, I certainly tend to agree with that. But there's another example a little further back that my colleague Chris Beecham, who's a legal historian at Brooklyn Law School, has written a terrific book, Invented by Law, about the Alexander Graham Bell litigation over the telephone, right? We consider Bell the inventor of the telephone, but the sort of antecedent question of, was the thing that Bell invented really a new thing called a telephone, or simply a hyper advanced version of telegraphs, which have been around for much longer, right? The line drawing that takes place is a highly contested, historically contingent sort of exercise, which has technologists weighing in on it, economists, lawyers, certainly, and the general public. Our intuitions are very, very closely connected to the things we're already familiar with. And the whole idea, of course, of the patent system and the copyright system and forms of innovation management are that we're trying to incentivize and create rules for things that, by definition, we have not seen before, and for which we will not have a ready vocabulary. And so to return to the point that Arthur made at the very outset of this thread of conversation, it's not that, I mean, I agree that common law development and patience, are virtues, but they're not virtues for some sort of platonic a priori reason. I think they are virtues because they require us to show the humility that we really have no choice but to show in the face of uncertainty about what the future holds. It's the responsible thing to do, not merely the sort of sensible policy-driven thing to do.
And so, talking about the uncertainty in the future, before we get to a couple other questions, it does. I think one of the potential issues here is regulators, lawmakers, and others, when looking at this decision, don't really understand how the technology works. Hear AI and see, think about a certain thing. There's also talk of AGI, artificial general intelligence, and now ASI, artificial superintelligence. I think those are all different questions. And the tools we have today are not intelligent the way people are intelligent. They're good at predicting the next word, and they can answer a lot of questions that are useful. But it's not a separate intelligence living on the computer that's like a mini human. That's not, and thinking about it that way goes down some very odd paths, and I think creates some of the problems which we're running into, or at least potentially running into. So on PTO regulations and questions, and one of these was in the chat. So besides the, how is an inventor using an AI system to help innovate? How does that change things? There's also questions about what these AIs, what impact on the person working with skill in the art the AIs have, and then also for creating prior art, which there's been some use of AI tools to do that over the years, and with questionable results, and now you can do a arguably better version. But how does that impact the system, and what are the potential problems if we change things too much in either way for those? And again, I'll open it up, whoever wants to start.
Yeah, I guess Joshua, I'll start on that one. So, we've been predicting for a while, and I think it's true and probably okay that AI should increase the level of ordinary skill in the art. If the use of AI can generate lots of different options that would render an idea obvious, so be it. We now have that as a new tool. Again, going back to history, just like the microscope would have done that for observations that before the microscope were much, much more difficult to make. So that seems okay to me. And there's another side to that point too, which is that, particularly in fields like the bio area, the small molecule pharmaceutical area, where decisions like the Amgen Supreme Court case, I think from now a couple of years ago, have increased the requirement to disclose species of an invention in order to get a claim for a genus, which is very important in that area. Well, now with the aid of artificial intelligence, once some species and a desired genus are known, it's actually not that hard, and inventors can do this, and it's completely legitimate to use the AI capability to generate lots more species in support of the genus claim. So that's helpful to the patent applicant. So there's some cost, if you will, in raising the bar on the POSITA, and there's some opportunity available here.
Dave, I'd like to second that. I think the way, Joshua, you framed the question, particularly in terms of whether the I in AI or AGI, right? The general intelligence, it's not intelligent in the way that we think. That's true. The question is, okay, well, so what is it instead? I think it is largely a nonsense generator. It's grammatically and syntactically understandable nonsense, but it is still basically nonsense in a large portion of what it generates. And the only way to know that is for a human to step in and exercise some oversight and judgment, right? I think the answer, and I know our audience is global, so let me turn to one of our most important cultural exports over the last quarter century, which is the television show Seinfeld. There's a great line in that show where George turns to Jerry and says, "Remember, Jerry, it's not a lie if you believe it." And well, as a legal matter, that's true. That's simply false without being a lie. And I think that epistemic question of, does the AI think? Of course not. Do we care about the truth content of what the AI is generating or the explanatory content of what the AI is generating? We certainly should if we're going to treat it as prior art, because the flip side of what Dave said is not only does this new tool, this powerful new tool, give us a great deal more information, it also gives us a great deal of sort of noise that teaches us very little at all. And being able to differentiate between options that have viable prospective innovative power and options that are really just nonsense is the sort of cardinal role, even of a person having ordinary skill, let alone the inventor who has greater than ordinary skill and is sort of capable of generating true innovation. So I think the way to think about this doctrinally is to step away from the red herring of patent eligibility. I think Rama is exactly right that the state of the law is too murky there to be of much value. But whether something is well enabled, whether something is sufficiently well described, whether it was obvious in light of the tools that were available to a person of ordinary skill, well, that set of tools now includes natural language processing, machine learning, Markov models, Markov chains, these subcomponent technologies of what we sort of broadly refer to as AI, taking a component by component analysis of what it is that technologists and innovators actually use and how we use them will give us a much clearer handle on whether a person of ordinary skill or a team of ordinary skill should reasonably have been expected to use this tool in arriving at whatever innovation they reached. And if the answer to that is no, they did something that people were not, sort of accustomed or expected to do, that's innovation. And if all they did was what everybody was already doing, we all use high throughput screening assays, we all use natural language processing, we all use microscopes. If that's the case, then a person of ordinary skill wouldn't have gotten there. We know how to answer that doctrinal question and set of questions much more easily than the eligibility question. And that'll do most of the filtering and sorting for us without the need to sort of grapple with the tough question of eligibility in every single case. That doctrine alone can't bear the weight of all of this sort of administrative filtering that the patent system needs to do.
Thank you. Okay, so with about 23 minutes left, I'll turn to some questions in the chat and questions in the chat and Q&A, and I'll kind of jump between them. So try to go back, answer questions we haven't already answered. Some of the questions I think we've covered, at least generally, so I'm not going to rehash them. But if you see I've skipped your question and you think you still have something to ask, please type it back in and we will get to it. So one new question. Looking ahead, what emerging technologies beyond AI will pose the next major legal challenges, and how can we start preparing for them now?
Well,
and again,
yeah, Joshua, I could start on that one, and Rama, I'm sure will have comments on it too, because for a number of reasons, including it has a huge impact on national security, but also it intersects with AI, and that's quantum computing, right? It's another technology that is in a doctrine or discipline, call it a technical discipline, that's been around my whole career, but is finally getting to the point where it's going to become practical and applications are going to start coming out. And you're going to see it intersect with artificial intelligence in terms of the enormous amount of computing power that it creates, and start solving some new important problems and also creating new risks because among its other attributes, quantum computing creates a world in which any current encryption can be dismantled in fractions of a second. So lots of change coming. Look for that technology to be vexing. Also look for it to do a lot to speed up and further enable artificial intelligence, and look for it to further challenge our IP system.
I couldn't agree more. I mean, we're already here sort of struggling with these questions with AI, and I think quantum is only going to amplify those challenges. And that's why I'll go back to, we really need a regulatory approach that's flexible and agile, because these things are moving fast, coming fast, and our the life of tech development is fast. The life of regulation or legal development is slow. So we can't revisit these issues every time the technology changes. So we need to put something in place that can address these changes. And I do think that the combination of AI and quantum computing is really going to sort of challenge all our legal regimes. Accountability, for example, data privacy, transparency, all of them.
And I mean, that comes with some real costs, right? So if there's no way to encrypt communications or transactions over the internet, we either go back to a world without that, where, banking is there's a lot more friction in doing money transfers than there is today. And then there's the challenge of, okay, so if you're going to have to, at some non-trivial cost, add to your security features to remain an online bank, is there a regulatory apparatus that demands that of everyone, or does it take, a bunch of people getting ripped off to get any one bank to do this? So, I mean, that's where regulators historically have kind of imposed costs, but have done it in a reasonably balanced way, typically across an entire economy. We've generally moved away from a lot of command and control regulation in the US, probably part of unleashing an era of greater innovation. So which way do we go, folks?
Yeah, so on that, I can say there are quantum encryption algorithms, so we can definitely encrypt things going forward. It just will be inexpensive new systems, and all current encryption is likely toast. I mean, a kind of funny example for anyone who remembers the movie Sneakers from the late 1980s, which is on hacking. And it's a really fun movie, and I recommend it for those who can go find it. It doesn't mention quantum at all, but the box in it is very much quantum. It's the only thing that I've thought about, said that for a couple of decades now, we're getting arguably close to it. And then what you can do at the end of that, when they do have access, is interesting to think about. And I guess the command and control does get into a little bit as we talk about international regulations and how China does things versus how we do, and what are the pluses and minuses to both of those. If anyone wants to jump into that quagmire. Okay, then jumping back to the chat. So one of the questions with AI tools generating so much new art and potentially flooding the market, how do you convince young artists to copyright their works, to enter the field, and to that they still have value? And to argue to some extent, you could have similar questions on the patent side, I think a little bit less so.
Well, I mean, the artist doesn't actually have to affirmatively take that many steps to, copyright their work, right? I mean, yes, you can file it with the Copyright Office, and with the publication, your book publisher or whatever will do that for you. But otherwise, you create it, you hold the copyright. And so it's more a question of how do we empower young people to understand the rights they have and to invoke them when they've created something that, gets ported into a video game. You invented the dance move. It's in the video game now. Is there any way for you and your community to benefit from that? That's sort of an open-ended area still, where we haven't seen, a lot of flow back to whether it's minority communities or others, where some of these things actually get invented. So I do think there's still opportunities to extend how we think about property rights to better accommodate for the fact that there are a lot of young people who are inventing a lot of things that end up kind of dispersing into the culture And maybe we don't have to assign property to every single thing everyone does all day long. So figuring out that line in the sand is pretty important. But some of the newer technologies and the way with which ideas flow, maybe there are some innovations we could undertake as a society that would help us as, basically culture becomes a major export.
And I think part of the subtext of this question, the set of questions from the chat, is what counts as art and who gets to decide. The manner in which training data is synthesized into the, what we would inaccurately and loosely refer to as the understanding of the AI, of all the different artists on whose work it's trained, and then generates, a landscape in the style of Albert Bierstadt or whatever. The manner in which human artists sort of reach their level of proficiency is very similar. You imitate before you sort of paint in the style of X, Y, and Z before you generate your own thing, right? Now, that's more elusive because we can't reduce what happens in the human mind to an algorithm. And for that reason, people who trained for years before they started painting landscapes were sort of filled with consternation when, someone like Ansel Adams comes along and starts taking photographs of landscapes. And okay, that's a technical, sterile, completely unartistic way to engage with the natural world. And that was a criticism, not aimed at the legitimacy of the technology, but really an epistemic question about what constitutes art. And again, who gets to decide? So if the question is, is copyright or any reform we might make to copyright going to solve the gatekeeping problem within an artistic discipline, I think the answer is probably no. But the definition of art will change. What counts as art and who counts as an artist will change. And that's a messy process that law is only one of many inputs sort of into. And I think, if what we want is for young artists to engage with this process, then some clarity and clear-eyed realism about what they're up against and what skills they will have to gain. It's very uncommon to find an artist under the age of 30 who isn't familiar with at least some of the digital tools, with the sort of suite of softwares that are available. Somebody who is trained only with watercolors and colored pencils is relatively rare. And so I think that's a self-correcting problem. And as I said, law is one component of many in that discussion.
Yes, I just saw an article about this yesterday about how many artists are moving off Instagram and to an alternative platform, which has different rules and whatnot with respect to AI. So we might see the market, and as well as things like Facebook and Instagram developing in response to some of these things to change some of their policies as AI develops in the future.
And I don't think we want to see a world where we don't have original human content being provided into this world. And so I don't think we should be encouraging that.
Yeah, I think the question was really getting how do we encourage humans to continue to provide it when there's this massive amount of content that's easy accessible.
And I think, yeah, I think that question is going to be resolved, probably not tomorrow or the day after, but I think there will be some resolution of how we provide that incentive and compensation to original content providers.
Yeah, and by the way, just one other comment on the issue of lack of human created content. We already know there's an AI problem called overfitting that occurs when a narrow band of data is used in order to inform the AI algorithm. You get answers that are in a narrow band and that are not actually useful by humans. So I would argue that we need human creativity and content more now than ever before if AI is going to achieve the promise that we all have for it.
Yeah, I mean, that gets into an interesting question. I've seen some arguments that somewhere 2025, maybe 2026, the largest AI models will have been trained on everything in existence, and to improve beyond wherever they hit there, we need more data. And there are interesting questions of, can synthetic data get us any further? And can generated by the current best systems actually help, or are we stuck without more data? And if so, where do we get it? It's just not a question for us to answer today, but it is a big question for the industry over the next couple of years. So I see a question from Alden Abbott about the Biden executive order on IP, which has a lot of regulatory features and also encourages the FTC to apply unfairness concepts in dealing with AI. Should the order be revised or looked at, and do any of the panelists have thoughts on the order?
I mean, generally speaking, the concepts of fairness as they are most squarely within the FTC's, regulatory purview, which is consumer protection, competition policy, things like this. I think those notions of fairness are not irrelevant to how AI is deployed. But if the question is whether those concepts should be imported into intellectual property, and I mean, that seems to be working a reconstitution of intellectual property into just another species of antitrust law. I don't think that's a conceptual move that is well advised, and I definitely don't think it should happen in the sub rosa fashion that I just sketched out. That's a debate, a much larger debate, that is not for the FTC to make unilaterally. I don't think the executive order authorizes the FTC to do that, and it would be a terrible idea for the FTC to use it for that purpose if they ever went in that direction. But there's no doubt that there are consumer protection implications for how the use of AI tools will affect the marketplace, and particularly in the way that the previous question was addressing, right, making sure the content creators are paid. Intellectual property as labor law and competition policy as a species of labor law is a place where I think some FTC developed notions of fairness are worth applying. Now, are they the right notions is where the policy debate should take place. But whether fairness is being brought to bear on the rights of consumers, the rights of content creators, new entrants into the marketplace, I think that's not an inappropriate place to have that conversation. I do think it should take place relatively far from the much more instrumental way in which we think about intellectual property as being about innovation and technological growth, and less about, frankly, politically inflected notions of fairness.
Okay, so one of the questions in the chat, by analogy, this sounds like we're advocating closing the barn door after the horse is gone. Must we experience the harm and then regulate, sacrificing those that are harmed during the AI advancement experiment? Or has anyone studied the net economic benefit of thoughtful regulation to avoid or minimize the harms versus light regulation that is reactive?
Yeah, so I mean, I would hear that as a question of sort of precautionary principle approaches versus, regulating, after we've got visible harms. And, my general sense is, as a historian, is that the US has wanted to see as putting causality in an uncomfortable place. But right, the regulations we've built have typically been after we have a better sense of what the harms are. So, a horse being out of the barn door whether or not that's a good analogy, but it's kind of an interesting one to think about because that horse could, become a useful animal in generating economic growth, or it could come and, kick you. And as it leaves the barn, we don't actually quite know which it's going to do. So sometimes it's worth seeing what it does and then figuring out what to do about it. And again, I mean, the one I know, the Food and Drug Administration, I know particularly well historically, a key piece was to have the scientific field advance, and the FDA played a key role in development of clinical pharmacology as a medical and scientific discipline, so that you could create testing protocols that in turn would help shape how the industry works, and ultimately then differentiated a science-based pharmaceutical industry from what were then called patent drug manufacturers, whose products actually were never patented, I should add. So, I mean, others on this panel, Saurabh, I don't know if people have formalized and sort of tested economic benefits, costs of precautionary versus command control or other types of regulation.
I'll just add that it is a very delicate dance of innovation and regulation, and we should be science-based, and that's one of the objectives of the new AI Institute that has been established under NIST, is to study the science of assessing these risks so that they can be evidence-based. And also, in anticipating or assessing risks, which are a lot of the requirements for AI, both in the EU as well as the US, and a lot of our big companies, frontier models and frontier AI companies are self-regulating and assessing these risks of what happens if we put this AI or this type of application into society. And, they are doing a solid job of sort of assessing what could happen and addressing and mitigating those risks. And we need to do certainly a lot more work there. But again, I think there are both industry and the government are working on strengthening our knowledge about the risks that AI poses.
So that raises an interesting question, which is in a more self-regulatory model, when you have failure, when you have a harm or other form of failure, that actually probably is treated as an internal trade secret because it helps you develop the next better AI system. And so there's an advantage to forms of disclosure and transparency that others learn of those failures, as opposed to having to kind of keep rerunning the test, which is expensive, or putting it on market, which then runs that risk of a broader harm.
Yeah, so the portion of the question that asks, is there research on this? The answer is absolutely yes. So most of the economic literature that I'm aware of actually follows from the regulatory theory and political science literature, which Amy knows very well, far better than I. But the sort of foundational work that I'm aware of that administrative law scholars and economists of intellectual property industrial organization have drawn on is this notion of police patrols versus fire alarms. This is a phrase that was popularized by Matthew McCubbins in a series of papers in the 1980s. And the notion is, do we actively go out and look for problems, or do we wait for somebody to sort of sound the alarm? And that's a rough proxy, not a perfect one, for the proactive versus reactive models of regulation. Now, some of that is a matter of political theory, not merely of regulatory theory, because if your sort of decentralized, relatively, democratic capitalist version of a good market is that regulators ought not to regulate unless there is a demonstrated market failure, then you've already sort of taken the choice out of the hands, or at least limited the scope of what regulators and regulatory theorists can talk about within that framework. But if what we want is to ask the sort of, foundational question, should police patrols be out there looking for problems affirmatively before they've arisen, and therefore endogenously changing the way that innovation is steered and directed? Because the presence of regulators looking for problems is going to have effects on the market and private ordering. Or alternatively, should we wait for somebody to sound the alarm? Maybe they have incentives to do that, maybe they don't, and maybe those incentives align with the public interest, and maybe they don't. If you're looking for academic scholarship on this, that's the place to start, because that's really the conception that IO economists and political theorists and regulatory theorists have really relied on to the best of my knowledge.
Thank you. With that, I see we're just about out of time. So I'll add, as a partial answer to that question, that for a lot of the concerns with AI, whether it's autonomous cars or robots in factories or discrimination in credit card applications or other tools, there already are regulations in the books that limit it, regardless of which AI or not behind it. So we do have things to protect in a lot of those areas. For some new potential areas, it's a more interesting question. And for some of the AI scholars talk about AI ending the world, and different people were betting on that, and that's a much more complicated question, and gets back to what we talked about. Even if we decided we wanted to stop things from moving forward as a country, we couldn't stop the EU from doing stuff, or they'll probably stop too, but China and others. So we really have to be thoughtful about what is the actual impact we can have of certain regulations, what can we influence and what can't we, and what should we be worried about in the near term and not. And with that, I want to thank all of our panelists for a great discussion. So thanks again to Arthur, to Rama, to David, to Amy, and to Saurabh. And for the Whiteboard Summer School students, I will see you back on the other Zoom in 15 minutes for your next session. And for everyone else, I hope you enjoy the rest of your afternoon.
Thank you.
Yeah.
Thank you.
Thank you, Joshua.
Joshua, thanks everyone. Bye-bye.